Let's talk about the Supreme Court, the highest court in the land, and the final word on what the Constitution really means for all of us. These 9 justices aren't just judges, they're the ultimate referees for American law, and their decisions can change your life in ways you never expected, sometimes overnight. Last year, something almost unheard of happened. All 9 justices agreed, 9-0, on a case that would have ripple effects across the country. That's like getting 9 cats to sing in harmony. Almost impossible. Usually these justices are split, debating fiercely, so a unanimous decision is a big deal. In May 2025, they fundamentally changed how courts judge police use of force, a topic that's been at the center of national debate for years. This wasn't about obscure legal technicalities, it was about the Fourth Amendment, which protects you from unreasonable searches and seizures, including deadly force by police. This is the part of the Constitution that stands between you and government overreach. For years, courts only looked at the split second when force was used, ignoring everything that led up to it. That meant officers' decisions, before the moment of force, were often off limits in court. The Supreme Court said, no more. They decided it was time to rethink how these cases are judged. They threw out that narrow rule and replaced it with a common-sense approach. Look at the whole story, not just a single moment frozen in time. The case, Barnes versus Felix, was a seismic shift, like changing the rules of the game overnight. Suddenly, everything leading up to a police use of force matters in court. Now, courts must consider the entire encounter, from the first moment of contact to the very end, not just the final, most dramatic seconds. This has huge implications for police accountability and your constitutional rights. It could mean more thorough investigations, more transparency, and a better chance for justice when things go wrong. But the surprises didn't stop there. Just as everyone was adjusting to this new reality, the court made another unexpected move. Just a month later, the court faced big Second Amendment cases that could have changed gun laws nationwide, and did nothing. No explanation, no debate, just silence. They declined to take up challenges to state gun laws, leaving everyone, lawyers, lawmakers, and regular people, confused and wondering what comes next. So, we have a massive overhaul in one area, and total silence in another. It's a reminder that the Supreme Court can be bold and cautious, all in the same breath. Only the Supreme Court could deliver this kind of legal whiplash, leaving us all to wonder what they'll do next, and how it will shape the country we live in. To understand this important change in the law, let's look at a case that set a new precedent, Barnes versus Felix. This case would go on to reshape how courts evaluate police conduct, and it all started with a single tragic event. In 2016, a routine traffic stop took a devastating turn. An officer pulled over Ashton Barnes, and within moments, the situation escalated. The encounter ended with the officer fatally shooting Barnes, leaving a family in mourning and a community searching for answers. When Barnes's family tried to seek justice in court, they ran into a nearly insurmountable legal barrier known as the moment of the threat doctrine. This rule made it extremely difficult for families like theirs to hold police accountable. Under this doctrine, judges were only allowed to consider the officer's actions at the exact instant force was used, ignoring everything that led up to that moment. It was as if the entire context of the encounter simply vanished from legal consideration. Imagine trying to judge a movie by watching only its final 5 seconds. You'd miss the build-up, the motivations, and the choices that shape the ending. That's what this rule forced courts to do with police encounters. But the Supreme Court saw the problem. In a rare unanimous decision, the justices rejected the moment of the threat rule. They declared that courts must look at the totality of the circumstances, meaning every relevant detail, not just a single instant. Now, judges and juries are required to examine the entire sequence of events. Did the officer's actions escalate the situation? Did their choices contribute to the danger? Did the officer create or worsen the threat that led to the use of force? These are now crucial questions that must be answered. The Supreme Court didn't decide whether the officer in Barnes's case acted lawfully or not. Instead, they sent the case back to the lower courts, instructing them to reconsider it using this broader, fairer standard. For civil rights advocates, this was a landmark victory. It signaled a shift toward greater accountability, and made it clear that context matters when judging police actions. From now on, an officer's conduct throughout the entire encounter, not just a single moment, can be scrutinized in court. Every decision, every action, and every escalation is part of the story. The whole story finally matters. Justice, at last, can consider every chapter, not just the final page. What does this new rule mean in practice? It's the difference between a lawsuit being dismissed and getting a fair hearing. Before, courts could ignore everything except the final moment, making it nearly impossible to hold police accountable for reckless conduct. Now, imagine an officer illegally escalates a routine stop and then claims to feel threatened. Under the old rule, only the suspect's reaction mattered. Under the new rule, the officer's actions leading up to the incident are part of the case. This gives civilians a real chance to have their full story heard in court. It shifts the focus to whether the officer's conduct was reasonable from start to finish. It's a major boost for those seeking justice after excessive force. Police departments will have to rethink training and tactics. The courtroom conversation just got a lot broader. This ruling isn't just a technical fix, it's a fundamental reset of the Fourth Amendment, one that will shape how law enforcement and the courts approach your rights for years to come. It's a moment that signals a shift in how the Constitution is interpreted in real-life situations, not just in legal theory. The amendment protects you from unreasonable searches and seizures, including the use of deadly force by police. It's the line between your private life and government power, and it's meant to keep that line clear and strong. But the big question has always been, what exactly counts as unreasonable? For decades, courts have wrestled with this, and the answer has often depended on where you live or which judge hears your case. Now, the Supreme Court says it's not just about the final split-second decision, but about the entire encounter between police and civilians. Every action, every word, and every choice leading up to a critical moment matters. This creates a single, unified national standard, ending the confusing patchwork of rules that changed from state to state and even city to city. No matter where you are in the country, your rights are now protected by the same clear guidelines. Police training will have to adapt, with a new focus on de-escalation, communication, and professionalism throughout every interaction, not just in the heat of the moment, but from the very start of an encounter. Officers who follow best practices and keep situations calm will be better protected under the law. But those who escalate or act recklessly will face more scrutiny, and their actions will be judged more closely than ever before. Importantly, it's not just judges who will decide if an officer acted reasonably. Juries made up of everyday people will have a bigger say, bringing community values into the courtroom. This is a big step toward transparency and accountability, giving the public more confidence that justice is being served and that their voices matter in the process. While this ruling doesn't guarantee specific outcomes in every case, it does guarantee a fairer, more consistent process for everyone, no matter who you are or where you live. Equal justice under the law just got a little closer, and the promise of the Fourth Amendment is now stronger for all Americans. While the court made waves on police force, it went silent on gun rights. Two major cases, one from Maryland, one from Rhode Island, challenged state bans on certain rifles and magazines. Gun rights groups hoped the court would step in, but the justices declined to hear the cases. Only 3 justices wanted to take them up. 4 are needed. That means the lower court rulings upholding the bans stay in place. The result? A patchwork of gun laws across the country. In some states, AR-15s and large magazines are banned. In others, they're not. The Supreme Court left the Second Amendment debate in limbo. The court's refusal to decide has big consequences. State bans on certain rifles and magazines remain in effect where lower courts upheld them. For now, your gun rights depend on your zip code. The Supreme Court's 2022 Bruin decision set a new test for gun laws, but lower courts are interpreting it differently. Some say history allows bans on dangerous weapons. Others disagree. Justice Kavanaugh hinted the court will have to address this soon, but for now, confusion reigns. The legal fights will continue, costing time and money. The fate of these laws is still up in the air. The Supreme Court just delayed the final answer. These Supreme Court moves highlight 2 fierce debates: police accountability versus officer safety, and gun rights versus public safety. Police unions worry the new rule will make officers hesitate in dangerous situations. They argue that split-second decisions shouldn't be judged with perfect hindsight. Civil rights advocates counter that accountability leads to better policing and public trust. On guns, supporters of state bans say they're needed for public safety, especially after mass shootings. They argue the Second Amendment isn't absolute. Gun rights advocates see these bans as unconstitutional and fear being left defenseless. The court's actions have fueled both debates, not settled them. The national conversation is only getting louder. So, what does this mean for you? First, your rights during police encounters are stronger. Courts must consider the whole story, not just the final moment. This empowers you to hold law enforcement accountable if excessive force is used. Second, gun rights are in limbo. The law depends on where you live, and the Supreme Court hasn't settled the issue. Stay informed about your state's laws, they could change soon. The conversation about both police conduct and gun rights is far from over. The Supreme Court's silence on guns won't last forever. For now, know your rights and keep watching the headlines.